I think we'll go ahead and get started this afternoon. I fully suspect we're going to have more join us throughout the duration of the program, knowing that we had quite a few registered to be online as well as folks to be here in person. Good afternoon and welcome to the U.S. Patent and Trademark Office. We are thrilled to have you here with us and are excited about this collaboration with the Virginia Small Business Development Center Innovation Commercialization Assistance Program. It's fitting that we have this program here in the great state of Virginia, which is home to remarkable inventors, innovators, and entrepreneurs. For this week, we celebrate not only President's Day, but also National Engineering Week. And it is not by coincidence that they coincide. This week was selected because it falls in line with the birthday of President George Washington. Why George Washington, though? Well, he was considered the first engineer of the United States, especially for his survey work. So keep that in mind the next time you visit Mount Vernon. George Washington was not only an engineer, though he was foundational to the creation of the U.S. intellectual property system. He in fact signed the first U.S. patents, beginning with the method for making potash and pearl ash in 1790. And while our system has changed over time, and patents are no longer signed by the president, they are still critical cornerstones of building strong small businesses and ultimately industry. Today, we are going to focus on just that, primarily through the lens of patents, although we're going to touch on other forms of intellectual property as well. We encourage you to participate, to ask questions, and to participate in the dialogue, whether you're online or in person. For those participating online, we encourage you to use the chat to ask your questions. We do have staff that will be monitoring the chat. After welcoming remarks and 2 presentations, attendees will have the opportunity to elect a breakout session. One breakout session, Life Science Ventures, will stay here in the auditorium. The second, focused on technology ventures, will depart the auditorium, head to the first floor, and then upstairs to a designated conference room. For virtual attendees wanting to attend the Technology Ventures breakout, a new link will be placed in the chat for your use. After breakout sessions, we encourage attendees that are here in person to visit our National Inventors Hall of Fame. The museum director there is eager to give you a tour of the beautiful museum and to tell you about the over 600 inductees to the National Inventors Hall of Fame. At this time, it is my pleasure to introduce Josh Green, who is going to provide a brief virtual welcome to today's program. Josh?
All right, thank you very much. I really appreciate it. And I want to also welcome everybody to today's event. ICAP and Virginia Bio are excited to be partnering with the USPTO, and we really thank them for the hard work that went into putting today's session together. For those of you who are new to ICAP, my name is Josh Green, and I am the Programs Director. ICAP works with technology and life science faculty, entrepreneurs, and startups in Virginia to support their commercialization efforts. Today's session is one of the ways that we do this, but the main focus of our program is our team of almost 20 ICAP mentors who support these groups one-on-one. We will have a follow-up email to this session that will likely come out tomorrow, and it will have a recording of the call and also provide some information about our program and how to get connected with an ICAP mentor. ICAP is a program of the Virginia SBDC and George Mason University, and we're funded in part by the university, the Small Business Administration, VIPC, Go Virginia, Virginia Bio, the Commonwealth Cyber Initiative, Northern Virginia Node, Prince William County, and the National Science Foundation. So we have a lot of supporters, and we're really appreciative of all of that support that they provide. And the Virginia SBDC itself is a network of 27 centers across Virginia that provide training and technical assistance to small businesses. And as it is with ICAP, this training is offered at no charge. I'm joined today by a number of my ICAP colleagues who are both in person and at different locations in Virginia. And for that, I'd like to thank our Richmond host, Activation Capital. Now, I would like to pass it over to our co-host for this event, Virginia Bio. And I think the folks at the USPTO will need to elevate, I think it's VA Bio is the name, to be able to turn on their camera and mic.
Thank you. It looks like I am all in. My name is Karan Trumbo. I am the VP of Operations here at Virginia Bio, and we are delighted to help put on this event with the team over at ICAP. We are the State Trade Association for the bioscience industry, and we are here to help all members of the life science industry here in the state. One of the ways that we do that are events like this, as well as larger events. And this summer, we are able to host the STEM to VA internship program. I want to encourage everyone to look into that. I'll put information in the chat. Please sign up if you are an employer and you need interns. We are able to match a $2,500 stipend for the summer. So get those students on board now and do all the extra work this summer while you have them. If you have any questions about Virginia Bio or the internship program, please reach out, and I look forward to today's event. Thanks all.
And we'll pass it back over to you.
Very good. Thank you, Josh, and thank you, Corinne. Thank you for that warm welcome, and thank you for the opportunity to collaborate together. It is now my pleasure at this time to introduce a friend and a colleague for our executive welcome. And it's Joe Thomas, Technology Center Director for Technology Center 2800. Joe?
Oh, thank you. Appreciate that. Thank you for inviting me, Liz. I am honored, and it is a privilege for me to be here to give a few remarks to all of you. My name is Joe Thomas. As Liz said, I'm one of the Technology Center directors here at the USPTO. Just to give you a brief overview of the organization within patents. So when patent applications come in, they're usually reviewed by examiners in three major divisions: the electrical, mechanical, and chemical areas. And PC 2800, which I oversee with some fellow directors, is responsible for reviewing patent applications directed to semiconductor, memory, and laser technologies. So there's a number of Technology Center directors throughout the patent office, about 30 or to 40 of us in different areas. So it is an honor and a privilege to be able to speak to you today. At events like this, I'm reminded of an old African proverb, which I like to quote to you. It says, if you want to go fast, go alone. If you want to go far, go together. Let me repeat that. If you want to go fast, go alone. If you want to go far, go together. And this event, I believe, is the first of the collaboration that we've had with Virginia Small Business Development Center, and in particular, the Innovation Commercialization Assistance Program. And I appreciate the remarks that were given previously by Josh and also VBio. So I appreciate those remarks. And it is our sincere hope that events like this would be a partnership in which we can work together and go far. So I'd like to encourage you to participate in the different sessions, and those that are joined us virtually, please engage through the different sessions as well. And we are really interested in hearing from you what your needs are, what your interests are, so that we can collaborate and be very effective in this collaboration. So thank you all and have a good rest of your afternoon. Turn it over to Liz.
Thank you, Joe. Thank you for being with us, and thank you for that warm welcome. All right, gang, this is when the hard work begins. This is when the real learning and education kicks in and gets started. I have the pleasure today of really warming you up as an audience, introducing you to the role and importance of intellectual property. And then I'm going to turn it over to my colleague, Albert Wong, who's going to do that really deep dive, particularly into patents and trademarks. But you may be asking yourself, and hopefully not because you've taken the time to be here either virtually or in person, you may be saying, why is intellectual property important? Why should I care? And the reason you should care is that intellectual property is core to any business strategy. It should be something that you think about from the very inception of having a business idea, of creating that thought of starting, building, and growing a business. All too often, we hear from stakeholders that intellectual property protection is a rainy day project. It's something they're going to do when they have more time, more money, or perhaps a better appreciation of what that thing intellectual property is. Well, unfortunately, sometimes by delaying and protecting your intellectual property, you're in fact precluding yourself from protecting your intellectual property. So if you walk away with nothing else today, I hope it is one, that you should always have intellectual property in the forefront of your thought. Now, I know as small business owners, you have a lot of things to think about, whether it's your hard assets, whether it's finding good employees, whether it's finding sales, promoting business, creating the environment for your sales. There's so many things to think about. But please don't put intellectual property to the side. Get help, reach out to the US Patent and Trademark Office, find a good intellectual property attorney, work with organizations that can help support you, such as the Virginia Small Business Development Center. So I hope that's one of your strong takeaways, but I hope you're going to get a lot more out of today as well. So as I said, welcome to the US Patent and Trademark Office. We are America's innovation agency. As we like to say, we saw tomorrow yesterday. You know, it's a little bit of a brain teaser. You got to think about that one. But truly, our patent examiners are seeing cutting edge technologies sometimes years, if not decades, before they will ever reach the marketplace. And we take this role very, very important, very, very seriously throughout all of the work that we do, whether it's registering US federal trademark, issuing US patents. Our over 13,000 employees take this work very seriously because by issuing a US patent, by federally registering a US trademark, we are issuing you a government right, a right to protect and enforce your intellectual property. This is just a slide that, as they say, is kind of a hockey stick of growth. I just heard that term for the first time and I was dying to use it. It shows you how our world is changing with respect to technology. As you can see, and as I commented, we issued the first patent in 1790. And this slide somewhat reflects our monumental, our really milestone patent, 1 million, 2 million, 3 million. We've issued over 11 million US patents since the start of the US patent system, over 11 million. And I fully suspect we're going to issue 12 million next year in 2024 if we keep up the cadence of issuing patents at the rate that we have been, and even with a little bit more expedition here in the next few months. I'm guessing 2024, just anecdotally, that's my thought. And who knows, maybe it will go to one of you. So why is intellectual property something that should be part of your business strategy? Well, there's a lot of reasons. First and foremost, it makes your company attractive to investors and buyers. How many of us here have ever seen the show Shark Tank? Invariably, what question do the sharks ask those individuals coming before them? Do you have any patents? Have you protected this invention? If it is an invention. I know a lot of things come before the sharks that might not constitute an invention. One of the sharks, big fan favorite, is Lori Grenier. What you may not know about Lori Grenier is an inventor herself. She has over 150 patents in her name. So she knows the role and benefit of having intellectual property protection. It makes it makes your investment, it makes your invention attractive to investors and buyers. It can deter infringement lawsuits. Certainly by protecting your intellectual property, by creating your intellectual property, you never hope or anticipate that someone is going to infringe upon your intellectual property. But you should always have that in the back of your mind. By having intellectual property, by having a US patent, by having a federally registered trademark, you are putting the world on notice that you have protected your intellectual property and they should stay away, that they do not have the rights to use it without your permission. Because that's what your intellectual property protection provides you. It provides you with the control to do what you want with it. As a patent owner, as a trademark holder, you have the opportunity to use your intellectual property as you see fit, whether that's keeping it to yourself, whether that's licensing it to others, whether that is selling it to others, whether that is giving it away freely. It can increase your leveraging power. Again, this goes back to that opportunity to make your intellectual property, to make your business, to make your investment attractive to others. It's a property right that can add value to a company's assets. Just like hard assets, whether it's a fleet of vehicles or a manufacturing facility or the commercial goods you're creating, those are all assets within your business. Your intellectual property is also an asset. It is part of your bottom line. And intellectual property is global. We recognize in today's world that very few of us are working just on a local level. If you're selling on the internet, you're working in a global marketplace. Intellectual property is infused in so many of our industries. We have a chief economist here at the US Patent and Trademark Office, as do many government agencies. And they've actually studied the fact that those industries that are tied to intellectual property have led to 47 million IP-intensive jobs. 41% of IP-intensive industries provide 41% of the share of total US GDP. This is, again, just really crystallizing how intellectual property provides assets and value into a business. And it's not just in individual businesses, it is in value for our economy as a nation. Again, just something from our chief economist's office. You can see how it actually breaks down across different types of intellectual property. And we are going to talk about those different types today, whether it's trademark, copyright, design patents, utility patents. And we'll talk about the difference between all of those today. So what is intellectual property? I'm sure for many of you in this room and many of you online, you're already familiar with what intellectual property is, its role and importance. But for those of you who may just be dipping your toe in the water of intellectual property, we like to juxtapose it against real property. We can all appreciate what real property is. It's that house, that car, that boat. It's those tangible assets that you have. Again, that you have that you can lease, you can sell, you can give away, you can assign to your heirs. Intellectual property, again, is not that different. However, it is creative property, property created by the mind, by you or by you working with others. But it is property that can be used in a variety of different aspects. So the types of intellectual property, there are 4 basic types. And today we're going to focus most on patents. But of course, as our name suggests, the US Patent and Trademark Office, we are also involved in the issuance of federally registered trademarks. The USPTO does have a role to play in copyright. Copyrights, while issued by the US Copyright Office, which is a part of the Library of Congress, the USPTO plays a role in copyright policy for the administration. So we help to lead those discussions as to what copyright policy should look like. Trade secrets are generally protected by contract law between an employer and an employee. It's also protected by the Uniform Trade Secrets Act. So again, today we're going to talk mainly about patents and trademarks, particularly patents protecting new and inventive ideas. As you'll see today, there are 3 different types of patents. utility, plant, and design. I think today's conversation is really going to focus most primarily on utility patents. And those are those patents that cover things that we think of as inventions, whether it's a mousetrap, a cellular communication device, or a bicycle. Trademarks identify the origin of goods or services. So think about protecting your brand. You may have a great invention, but when you get it out there in the marketplace, how are people going to refer to your invention? It's going to need a name. Your company needs a name. People need to know where to find you and how to distinguish your product from others. Trademarks help us to build up quality in our brand. It helps to distinguish, it helps to infuse quality, both so the consumer can appreciate that quality, as well as we can have the manufacturer want to infuse quality. So what is a patent? A patent is a right to exclude others from making, using, selling, offering for sale, or importing the claimed invention for a limited period of time. For utility patents today, that is 20 years from the date of first filing. So if you were to file a patent application today and receive a US patent, congratulations. It would be good for 20 years from the date of filing. As you'll see in our conversation, design patents are good for 15 years from the date of issuance. And oftentimes, these forms of intellectual property play well together in what we call an intellectual property portfolio. So when thinking about the 4 different types of intellectual property, you want to think about each with respect to the endeavor that you're undertaking, because you may be creating one or more types of intellectual property that you want to protect, thus creating this intellectual property portfolio. The utility patent is for a limited term, as I said, 20 years from the date of earliest filing. Patents, just like every other form of intellectual property, are territorial. Patents, trademarks, copyrights, they only protect you in that country which issues you that right. Anecdotally, people say that when protecting your intellectual property and thinking about protecting it internationally, you want to think about where you are going to manufacture your product, where you are going to sell your product, where your largest competitors are. But thinking about protecting your intellectual property internationally is a heavy consideration, and one that is certainly advised that you use the services of a registered patent attorney or patent agent. Because can you paper the world with international patents? You can, but it's a very expensive proposition. So you want to choose wisely. So as I said with the trademark, the key purposes are to allow consumers to identify the source or producer of different products and services, helping in your buying decisions. They say on average, each of us experiences approximately 1,500 trademarks in a given day. I think that's a difficult calculation to make because it might just depend on what your day looks like. I know if you walk down the cereal aisle of the average grocery store, you probably interact with hundreds of trademarks in a given grocery store aisle. They also encourage trademark owners to provide goods and services of consistent quality and to build goodwill in the trademark. Now, one should never disregard the use of a trademark, because trademarks for some businesses can be their most valuable form of intellectual property. I know for many of us, we always think the patent is where it's at. I can't tell you how many inventors I've heard say, I've got my patent, it's my ticket to $1 million. Really, your patent is just that first step. There's so much more that has to take place. There's so much more work and research and outreach that has to take place for that $1 million to land in your pocket. But don't disregard the value of a trademark. Coca-Cola is on record saying they could lose all of their hard assets as long as they maintain their trademark portfolio. They have the value in the business. They have the bulk of the value in the business. And Coca-Cola is one of those right up there. If you were to look at a listing of most valuable brands, you know many of them. You'd recognize probably all of them. It's Apple, it's Google, Coca-Cola. So what is a copyright and why does this pertain to you? Well, a copyright protects an original work of authorship. And there's many, many different types: literary, dramatic, musical, artistic. A work of authorship that is placed in a fixed medium. So in the context of a business, it could be your website. It could be your packaging. It could be the instructions that come with your packaging. It is any artistic work of authorship. Again, the Library of Congress, the U.S. Copyright Office administers registration, and the USPTO advises on issues regarding copyright. Now, copyrights are interesting because copyrights are what we call self-authenticating. By merely placing that work in a fixed intangible medium, you have secured a copyright. So, has anyone written a letter today, or written a story, or written an email? You've probably secured a copyright today just in those simple activities. Now, in order to achieve a copyright, there does have to be a certain level of creativity. So if you just wrote a grocery list, that may not rise to the level of something protected by a copyright. But if you do want to enforce your copyright and take advantage of all of the benefits of a copyright, you are encouraged to register it with the US Copyright Office. Copyrights are good for 75 years plus the life of the author. So it's an exceptional duration. And I'm sorry, I should back up to say that trademarks can potentially be good forever if you continue to use that mark in commerce and you continue to register it with the US Patent and Trademark Office on a 10-year basis. So an extremely valuable form of intellectual property. So last but not least, what is a trade secret? Any information that derives economic value from not being generally known or ascertainable. Again, like a copyright, it can be a wide variety of things. It could be a customer list. We always think of formulas or recipes, and those are two great examples. The recipe for Coca-Cola, the recipe for KFC chicken. Now, the importance of a trade secret is one, like a trademark, it could have a duration of forever if you maintain it as a secret. So you must take steps to maintain the secrecy of that information. And that's one of the greatest challenges of a trade secret. So I'm about to wrap up here so I can turn to my colleague Albert to do a deep dive. But developing an IP strategy, how should you do that? Again, it should be from the get-go. It should be from the very beginning of thinking about starting and building and growing a business. Knowing your company's IP assets and prioritizing them. What are they? Have you created an IP portfolio, or should you be creating an IP portfolio? And if so, what kind of help should you get in doing so? Knowing your competition, knowing the pace of innovation and opportunities, knowing the different forms of intellectual property. And that's why you're here today. So we welcome you here today. We're glad to have you with us. I will let you know that you will get all of the materials that are shared today. And with that, I'm going to give you a little sneak preview of something you are going to get in your slide. Time being what it is, I'm not going to go into these slides, but the remainder of my slides are all about engaging with the USPTO. Resources that we have available on our website, resources for legal assistance, resources to help you with patent and trademark searching. So just know that these are going to be coming to an inbox near you, and I hope the tools and initiatives and programs that are in these will be helpful to you. So a little homework for you when you get home. With that, I'm going to turn it over to my colleague, Albert.
I'm going to be previewing in a little more depth the various types of intellectual property with the focus on patents. First, a word from our legal department. This presentation is for educational purposes and is not intended to constitute legal advice or to endorse any product, services, or trademarks. So, as Elizabeth correctly presented, intellectual property, it can be a very valuable asset to a business, as much as physical property. We're all familiar with physical property. Intellectual property, as Elizabeth said, is an intangible creation of the mind. And so that presents a bit of a problem. With physical property, you can always lock it up in a safe and keep it to yourself. With intellectual property, once that information is out there, it can be freely copied and used by other people. So The solution to that is found in our Constitution, which granted Congress the right to protect and promote the progress of science and the useful arts by securing to the authors and inventors the exclusive rights to their creations. Now, because it's a right that's created by Congress, it's going to be subject to change. It's not necessarily going to be fixed forever, and there are going to be a lot of requirements to secure this right. So I'm going to be talking about the 4 different types of intellectual property and how they might be used together and which one you might use for what purpose. So the first type is you're probably familiar with is the patent. And patents come in 3 different flavors. There's the utility patent, there's also a design, and there's a plant patent. And I'll cover each one of these in a little more detail. In addition to the patents, there's also trade secrets, there's trademarks, as well as copyrights. Whenever you're dealing with a patent, you should also always consider whether a trade secret would be a better form of protection, because with patents, you're required to disclose to the public what your invention is, and therefore whatever you have will be known to the public, whereas something in a trade secret can be kept to yourself and maintained a secret for a unlimited duration as long as the secret is kept private. With a patent, after a certain period of time, the property rights goes to the public, and the public is then free to make and use your invention. So let's look at a common device that actually has quite a bit of intellectual property, which is your standard cell phone. We're probably pretty familiar with it. And so oftentimes a cell phone would have certain trademarks like the Apple logo or iPhone, which denotes the maker of the phone. Within the phone itself, there is going to be a numerous plethora of different inventions, whether it's display, the battery. These are all going to be protected under patent. Even the shape of the phone can be protected under what we call a design patent. And in terms of copyrights, the software code, the instruction manual, and even the ringtone can be protected. As far as trade secrets, we don't know what they are because the whole purpose is to keep them secret, but you can be sure that within any phone, there are some trade secrets that people have decided that it's better to keep them secret than to disclose them as a patent. So let's take a quick look at some trade secrets. Formulas, the search algorithm for Google, formulas for recipes for like Kentucky Fried Chicken are very common examples of trade secrets. The reason they kind of work very well is that things that are not very easily reverse engineered, that require a lot of trial and error, often better kept as a trade secret and protected as such than to disclose them as a patent. And trade secrets come in a variety of different formats. For example, anything that is commercially valuable to your business can be considered a trade secret. These can include things like customer lists and things of that nature. Copyrights are original works of authorship. They can be in form of literary, dramatic, musical, things like movies and photographs, sound recordings are very common types of copyright. And these are protected through the Library of Congress. The requirement for copyright protection is that they must be fixed in a tangible form of expression. So in other words, it's not something that's in your mind, it's captured, whether it's by a camera, a recording device, or even just written down on a piece of paper. Whether you intend to protect it or not, the minute they are fixed, there's some protection that automatically arises. You can obviously register your copyrights with the Library of Congress, and that will give you additional protections. It's important that the works be original, and they have to have some level of creativity. So merely taking something that's already existing and reproducing it in a different way is not going to be subject to copyright protection. So these are some of the very common examples, and you can see that it's a pretty wide range of things that can be protected by copyrights. Things that are not protected are things that are not fixed. Titles, names, something familiar symbols, let's say the ingredients on a box. These are kind of examples of things that are not protected by copyrights. Also works that have common ownership and no original authorship. And the duration of a copyright is actually quite lengthy. It's the life of the author plus 70 years or 95 years from publication for a business. The advantage of registering a copyright as opposed to just relying on the default protection on creation is that you can file a suit in the federal courts, and it's very useful and helpful to enforce your property right if your copyright is registered. We're fairly familiar with trademarks because we see them everywhere. The trademarks can be a form of a word, a name, symbol, anything to distinguish your goods and services to indicate their source. What's really kind of interesting about trademarks is that you can develop a trademark without even knowing it. Oftentimes, people become aware of their trademark when other people are using what they've created, and they say, "Well, that looks like mine." Why are they allowed to do that? And so you don't necessarily have to register a trademark with, but when you register with the trademark office, it comes with a lot of additional rights. First thing it does is it puts people on notice, so other people that you don't want using your trademark, it lets them know that this is your proprietary right. The other really big advantage is that it prevents other people from registering a trademark with the trademark office. And what can be a trademark? It's actually quite broad. It can be a word, a slogan, symbol, design, or combination. So anything that represents your brand, that when people look at it and say, "Oh, that's associated with this product," that can automatically become a trademark, even without registration. So the advantage of trademarks is brand recognition. It distinguishes your goods from others and competitors in the marketplace. Certainly, a branded product is often worth quite a bit more than something that's generic. It allows you to register it with the patent office, and it can serve as a basis for foreign filings of trademarks if you decide to go internationally. And whatever trademark you register with the patent office is also made as part of a database so that the public can be aware of what is considered protected property versus something that might be free for other people to use. So these are well-known examples of trademarks. And as you can see, a company or a product can have more than one trademark. The important thing to recognize is that trademarks are always associated with a class of goods. So it is possible for two people to have the same trademark if the goods are very different and there's no confusion between the different classes. These are also other examples of trademarks that are a little different. It can be in the form of a sound, a color, or even a smell. And you can clearly see that the Tiffany turquoise box is something you would automatically recognize even without any printed advertisements. In terms of marks, we generally, they vary in terms of strength. The arbitrary, the fanciful marks are generally considered stronger marks, and they are generally more valuable because um, what comes to mind is a single company or a single product. Something that is more descriptive and suggestive generally is considered a less stronger mark because it's not as closely tied to you as a business or a product. So this is our example of strong marks versus the weaker marks. So things like Xerox and Microsoft. Um, when you hear that, you clearly associate that with one brand versus something like Coppertone for suntan lotion. Um, you might not envision one company when you hear that type of mark. So to recap, descriptive marks, words that just describe a good are considered weak marks. And there are obviously some marks that are just so common and generic that they just don't have any protection whatsoever. So once again, you don't have to register a trademark to have protection. The minute you create and use it, there's some protection that's associated with your mark. But when you register with the patent office, there's some additional benefits. You can use the R in a circle to kind of put people on notice that it is protected by a trademark. You can prevent the importation of infringing goods. You can use it as a basis of attaining a trademark in a foreign country. And it certainly helps in terms of enforcing your property rights because it gives you access to the courts as well as additional damages. So, it's not necessary to register a trademark, but it's often advisable to do so. So let's get into the big gorilla in the room, which is patents. Patents is quite different than the other forms of intellectual property. The other forms of intellectual property, the minute you create them, there's some right that just comes at the moment of creation and use. With a patent, you don't get a right until it's been granted by the office, which means it goes through an examination procedure to determine if you fulfilled all the requirements. There's a few very interesting points with regard to the patent. The first is it's an exclusionary right. It allows you to prevent other people from making or selling your invention. Oftentimes, people mistake a patent as a right to make an invention. If there's no other right, if your invention doesn't include something that is protected by another patent, then you do have the exclusive right. But oftentimes, inventions are made of other components, which may also have a patent associated with that. And into that type of situation, the patent holder of a part of your invention may preclude you from making the invention when they're enforcing their patent rights. The other thing is the patent is of a limited term, and it's limited to the geographical country that issues that right. So if you get a patent in the United States, your rights terminate once you cross the border. So for every additional country you want a patent right in, you would have to file and be granted a patent in those countries. The patent term for utility patent is 20 years. It's a limited right, and it serves two purposes. One, it makes clear who owns the property right, and it also makes known inventions to the public so that future developments can be made. It's generally considered good policy to promote science and inventions. And one way of doing it is by looking at what other people have created and making improvements on it in the process. So Once again, there are three types of patents. The utility patent is the most common. Design patents are also quite useful in their own way. And the least common patent is the plant patent. So we'll look at each one individually. The utility patent protects the way an article is used and function, whereas a design patent protects the way an article looks. It may have some utility, but the main purpose of the protection is protecting the way something looks. Plant patents cover essentially various types of plants that are asexually reproduced. So let's take a look at a design patent. Generally, design patents are shown as drawings. They could be the entire drawing. In Figure 1, this is like a cup, and the shape of the cup is what is being protected. But it doesn't have to be an entire item. Just an ornamental stuff that's applied on a cup can also be protected as a design. In this case, the way you denote that is the dotted lines. The dotted lines indicate that this is not part of the design, and the other solid lines are the indication of the design. Figure 3 is a sort of a combination. It's an article of manufacture as well as a design placed on it. Now, you might be wondering, designs kind of look like they could be kind of like trademarks. So what is kind of the difference? Well, the design is always associated with an article of manufacture. It's something you make versus a trademark is more intangible. It can be word or a logo. However, intellectual property attorneys are often very clever, and they tend to want to push the boundaries of stuff. And so things like oftentimes like a shape of a container, like a Coca-Cola bottle, it is an article of manufacture, but it's also protected by a trademark. The concept, the shape of the bottle, that will be subject to a trademark. However, that does not preclude someone from actually getting a design patent on the bottle itself to prevent someone from making that bottle. What's very important with the design patent is the drawing. The drawings is what gives you the scope of protection, and therefore, when you're filing a design patent, it's very clear that your drawings must be very clear. So your lines, the details, particularly what you consider important, should be made very clear. And if it's not clear, that could be a reason why you may not be granted a design patent. With any patent application, it's very important that when you file your application, it must be complete, because you're not allowed to alter or add to it after filing. So always double check and make sure that you haven't left something out and everything is as clear as possible. As I said, utility patents, it covers any new, useful product, machine, article manufacture, or composition of matter. So these are your common 4 classes of things that fit under utility patents. A process can be steps of doing of making something. It could be something that might be implemented on a computer. What you're protecting is the steps that you're taking to accomplish either some sort of goal or something you're manufacturing. A machine is like a computer. It's something where various components are put together that perform some sort of useful function. It can be another thing a utility patent can be is an item of manufacture. So it's something that's made by a machine. And lastly, it can be a composition of matter. So chemical compound, something of that nature would be considered a composition of matter. So if your invention falls under any of the following category, and sometimes it may actually fall under more than one category, it can be protected by a utility patent. These are the parts of a utility patent. There's generally a title, an abstract, which is generally a one paragraph description of the invention. There's usually some drawings. There's some background information to help the examiner like myself understand your invention. There's usually a brief summary to explain your invention, as well as descriptions in terms of the figures you might use. And there's a section, what we call the detailed description, where you go into depth so that someone can actually understand how to make and use your invention. And with utility patents, they always conclude with something called claims. And claims are what gives you the scope of protection, because when you disclose an invention, it's not exactly always clear what you're trying to protect. And what the claims do is it's sort of like a template where we try to match up the words of the claim with something that is existing out there, or someone is making a product, and we'll determine whether something is going to be eligible for a patent, or whether someone has infringed your patent if you've been granted a patent. And so the claims are the most important part of a utility patent. The drawings are generally, most utility applications include at least one drawing, and it's usually there to help people understand the nature of the invention. And it must be part of your application when you file it. It cannot be added later on. And everything that you put in the claims should also be found in the drawing. You can have as many drawings as you think is necessary. And in general, the drawings are black and white and not color. So these are examples of drawings found in patents. And there's certain things I want to point out in terms of format. Generally, if you have different figures, they're labeled as Fig 1, Fig 2, and Fig 3. You'll see that there are reference numbers associated. And the reference numbers are the elements that you consider important that make up your invention. In general, the same part should have the same reference number, even in the different drawings. For example, let's say you have a keyboard. If you consider a group of keys kind of the same, you would give them the same reference number. If there is some unique key that you want to point out, then that should be given a different reference number. For each of these reference numbers, it is suggested that you pick a term that describes it. And you should be very careful in terms of picking these terms, because these terms are generally going to be used in your claims to define your invention. So that's something you should think about. You generally want to use terms that are known in the field so people can recognize what they are. But a lot of times you don't want to be excessively specific, because that could kind of narrow your protection a little more than you would want. The example I usually give is a bicycle. One of a great term to use for a part of a bicycle is the frame, because everyone kind of knows what a frame is, but there's a whole different variety of them that's not very specific. So in some ways, it's clear enough so that everyone knows it, but it's not so specific to limit your scope of protection. Generally, the figures are combined with what we call the specification or the written description of the invention. This is the portion that you explain how your invention works and how to make and use it. And when you're describing your figures and your invention, you're going to refer to those reference numerals you found in the drawings. And those terminology you use with these numbers should be also in your specification and they should be very consistent. So don't change that terminology throughout your specification because people may not know what you mean. So use consistent terminology and use it throughout your specification. When you're filing your patent application, the specification should be double-spaced with a margin around it. And generally, you put a number either at the top or the bottom of each page of the specification. This is generally to make sure that if a page is left out or the pages are misnumbered or in a different order, that people can figure that out. In some ways, people will also put reference numbers for drawings. Let's say you have 5 sheets of drawings. I've seen attorneys refer to them as 1 of 5, 2 of 5, 3 of 5, 4 of 5. There's no requirement for labeling the pages of a drawing, but for the specification, each page should have a reference number either at the top or the bottom. And finally, we'll get to the most important and oftentimes the most difficult part of the utility application, which is the claims. Once again, the claims define the invention, and it's what you're going to enforce to protect your invention. And everything in the claims should be found in the specification. So any terms and phrases you put in the claim, you should also have those in the description and preferably shown in the figures itself. This provides what we call an antecedent basis because when someone is reading the claims, they're also reading your specification, which helps them understand what your claims are. So when you're writing a claim, this is one thing you should keep in mind. Claims can be very specific, or they can be very general. And in general, you want to write claims that are kind of in between. If they're too specific, you're not going to have a lot of protection because they're going to be easy to design around. On the other hand, if you get too general, it may not be patentable, so you may not get any protection from it. And I'll give you some examples of a claim that is too specific and a claim that is too general. So before you write your claims, you should ask yourself, what is the invention? What are the pieces and parts that make up the invention? And how do the pieces and parts fit together? So the way I kind of describe a claim is sort of like a recipe. A recipe's got a list of ingredients. It's also got steps to combine the ingredients. And a claim is a combination of both. It is the parts that make up your invention and how they're put together. In general, a broader claim is a claim that has fewer parts. And as you add more and more details to the claims, they become more and more specific, and the protection you have is less and less with each additional detail. You should also ask yourself, are there multiple versions of the invention? Sometimes there's more than one way of doing it. In that situation, you might have different sets of claims to cover what we call different embodiments. So once again, I'd like to emphasize that you should think strategically. How can you get the broadest valid claim possible? And draft claims, you can draft different claims with a variety of scopes. So you might have a few claims that are broad, and then each additional claim under it may be more and more specific. And this is something you should keep in mind, not just at the time of filing, but during the prosecution of your application, because you might become aware of more things out there that may limit the scope of your protection. So in general, a claim is a single sentence. It has what we call a preamble or an introduction, and it's got generally something called a transitional phrase. Generally the word comprising or consisting of, and I'll get into the details of why you would use each one. But the most common transitional phrase is comprising. And that's followed by what we call the body of the claim, which are the elements that make up your invention and how they're put together. When we talk about claims, we talk about them as being open-ended and closed-ended. What open-ended means is that your invention is not solely limited to those elements that are listed as part of your claim. You might say, well, that seems kind of odd. The purpose of that is that your protection is not limited to what is actually there. The fact that people can add an element to your invention is not a way for them to get around your patent. And so when you have an open-ended claim, you can add anything to the body of that claim, and that would still be protected by your patent. On the other hand, with something that is closed-ended, where you use the term consisting of, for someone to infringe your patent, they are limited to the exact words of your claim. So you might ask, well, when would I use one versus the other? Generally, the closed-ended example is used for something like drug compounds or chemical compounds, where if you add something to it, it's not going to work or not going to work as intended. But for most things that we find in ordinary use, you can freely add whatever you want, whether it makes sense or not, to a existing invention as defined by the claims. So let's look at an example of a claim that's considered too broad. Where you've invented, let's say, this yellow vehicle, and you're trying to get some protection for it. And so you've written it as with a preamble, a vehicle comprising. It means it's made up of these components: frame, first and second front wheel, first and second back wheel aligned with the front wheel, rotatably attached to the frame, with a seat and a removable top. The reason this is too broad is that when we take a look at the words of your claim and we match it up with something that is existing, like a stagecoach, we find that all of the elements that you've recited are found in this existing item. And therefore, a claim like this is considered too broad and not patentable because it's not reciting anything new. When that happens, all hope is not lost. You can go back to the specification and look for additional details to add into the claim. So just remember, anything that is in the application at the time of filing can be added to a claim to modify it. So in this case, the applicant has decided to add a whole bunch of details to make it patentable. Now, all of that is really required is for one thing that is different enough to make something patentable. It doesn't have to be a whole bunch of stuff. In this case, the applicant has added a motor, it's added a yellow frame, hinged doors, glass windows, red lights, metal bumpers. By adding all of this additional detail, it's made the claim very, very specific, and it's reduced the scope of protection. So this is clearly an applicant that wasn't thinking very strategically. They could have added just one thing that they thought was very critical. For example, with a claim like this, with a yellow frame, someone can easily avoid the protection of a patent by just making the frame orange of a different color. So you probably don't want to add something that specific to your claim just to get a patent. So you want to think strategically: what is critical to your invention, what is absolutely necessary, and add that to the claim to make it slightly more specific, to make it different from, in this case, the stagecoach. A lot of inventions, they come in various forms and improvements over the years. These are all the different lighting devices. It starts with a light bulb, it goes to incandescent bulbs. Uh, you have finally to LED devices. Um, One of the things I like to point out is that inventions are um, very specific items. They are distinguished from things like an idea. So ideas generally are not patentable. You can imagine that if you came up with the idea that you were going to create light from electricity, and you've invented a light bulb, but if we were to allow you to have protection for a very broad, abstract idea, you would actually preclude other people from making things that are new, like a fluorescent tube or even an LED lighting. So that's why when we're talking about inventions, it's important to have the specific details as to what makes up your invention, because what is disclosed is what you're going to get protection for. There are two main requirements as to what's patentable. The first is that something must be novel, which means it must be new. In other words, it didn't exist prior to you inventing it. That's a pretty easy bar to overcome because anything that is not a carbon copy is considered new. That's why we have another secondary requirement called non-obvious. Um, this it's a kind of a abstract concept that's a little hard to understand. Within any field, there's some known things that people do in that field. For example, in the field of bicycles, you paint bicycles, you may join parts, you may attach parts. Um, and For those differences, those are considered obvious. And in general, a minor difference that's considered obvious is not considered patentable. There might be, in some ways, a little bit of judgment as to what's considered obvious. But in general, if it's something that someone would generally practice in a field, it's considered obvious. A well-known example of this is just substituting one part for another that's equivalent. To use a baking analogy, substituting flour for a flour substitute, something that's gluten-free, would probably be considered obvious. And if your differences in your invention from the what's known and out there is just this minor difference, it's not going to be considered patentable because the differences are just considered obvious. Now, you've heard me talk about prior art. And what is prior art? Prior art is the body of knowledge that exists out there prior to your invention. And it's what we use as a patent examiner to make a determination as to whether something is meritorious for a patent or not. So when I make a decision as to whether something is patentable, it's not just my opinion. It's going to be based on some things that I'm going to show you. I'm either going to show you a reference that includes all the elements of your invention, so it's not new, or I might use more than one of these references to show you that um, one of these references has most of the elements of your invention, and another reference might have the other corresponding parts, and it might be in the same field so that someone of skill in the art would understand his part A, portion A, portion B. They can be put together in a very obvious way, and therefore it's not subject to a patent. Therefore, before you file for a patent, oftentimes it's a pretty good idea to do what's called a prior art search. That gives you some sort of idea of what's out there, what you should focus in terms of your invention. And when you're writing the claims, you can start off with claims that are distinct and patentable. And you could focus in on areas that are important to your invention. It's not a requirement that you do a prior art search, but it's going to result in a much better application with a greater chance of success. When should you file an application? Well, the short answer is as soon as possible. As soon as you have a complete idea as to how to make your invention, and your invention falls under one of the 4 categories, that's when you should consider filing your patent application. In general, you would want to file your application before you disclose it to the public. If you should happen to have disclosed it to the public, in the United States, there's 1 year in terms of the disclosure and the time of filing. In terms of foreign applications, there's not a 1-year grace period. So that's something to be cognizant of before you make your invention known to the public. So how does what is the pathway to a patent? Well, you first start out with invention, and when your invention is complete, it's what we call a reduction to practice. In the old days, you would make a patent model, so you would actually make your invention. Today, it's not. There's no requirement that you make an invention. You just have to know enough to in terms of the pieces and how they're put together. And once you have once your invention is complete, you have 2 choices. You can file what we call is a provisional application, which is what we call an informal application. The closest analogy I can give to you is like a small claims court. You just go out and you tell it to the judge. As long as it's understandable and complete, you're good to go as a provisional application. Now, the standard application is what we call a non-provisional application. This is subject to all of the requirements that I talked about earlier in terms of the drawing, the specification, and they have to be in a certain form, and they have to be ordered a certain way. That non-provisional application will be examined and will result in a patent, and the term of the patent will be 20 years. So you might wonder, well, what's the purpose of this provisional application? Well, oftentimes you're not, you may not have the resources or not have an attorney ready to file your application. You might want to get something in to the patent office to preserve your place in line, because the way the U.S. patent system works is the first person to file your application gets the patent. The second person gets nothing. So it's important to be first in line, but we're not always necessarily have the money or the resources to hire that patent attorney. And so the provisional application actually solves a lot of these problems because it's simple, it's inexpensive, and it allows you to hold your place in line for 1 year. And during that year, you can work on the non-provisional application. As long as you file it within that year, the filing date of the provisional will be maintained. After 1 year, the provisional goes away, and your place in line is lost. Now, you can always file a second provisional, which will give you a later date. But in general, the provisional application is optional. You can go directly to the non-provisional if you choose. It's important to note that since the provisional application is merely a placeholder, it doesn't result in a patent. You must file the non-provisional application and have a successful examination to get your patent. The requirement for provisional is actually pretty simple. You have to have a complete description of the invention to allow someone to make and use the invention. So just like any other patent application, the details might not be so correctly arranged, but it all must be there, and you cannot add to it. So it's important that even though a provisional application is an informal application, it should be complete. And it's generally a pretty simple process. Um, uh, in general, you fill out what we call a PTO SB16 form, which is shown here. And all that's required is some basic fields: the inventor's name, his address, the title of the invention, your address, um, attorney information if there's any, and a filing fee. And it's a pretty inexpensive process, and it's made as simple as possible. Unlike the non-provisional application where there's an additional charge if you decide to file it in paper, with the provisional, fill out that form, include all of the information as far as your invention goes, mail it into the office, and as soon as we get it, you could, you have a provisional application and a filing date. Once again, I'd like to note some differences. A provisional will not result in a patent without the filing of the non-provisional. After 1 year, it's abandoned. There's no requirement for those difficult claims to write. You can write those claims at a later time when you do the non-provisional. But be cognizant of the requirements for claims. That means that you should be careful in selecting your terminology, and you probably should include a few drawings because when you file the non-provisional, it's going to be based on your provisional. So the details that are found in the provisional are going to be the basis of your non-provisional. Now, you can always kind of add some details if you've left it out, but in doing so, what you may lose is you may lose that earlier filing date. So, so when you're filing the non-provisional, always make it as complete as possible. But when you're doing the provisional, that should also be as complete as possible. So how does the examination process go? Well, it starts off with you filing a non-provisional application. And after a certain period of time, it will be put on my docket. And I will do an examination of your application. I'll look at your claims to see how well they're written. I will look at the scope of protection. I will do a search of the prior art to make a determination as to whether you fulfill all of these requirements. If you fulfill all of these requirements, then you'll get something called a notice of allowance, which is your indication that your application has been approved for a patent. That doesn't happen a whole lot. A lot of times there's there's a little bit of back and forth between the office. So you'll usually get something called an office action that will indicate some deficiencies, and you'll be given an opportunity to amend your claims and to make arguments to convince me as to whether a patent should be granted or not. And this process can go back and forth more than once. If you're able to convince me in terms of either amendment or arguments, then that results in a patent. If you decide that the arguments I present and the art I present are not worth getting a patent, you can just do nothing in terms of response, and then after a period of time, your application will become abandoned. On the other hand, if you disagree with my determination, you can appeal to a neutral third party, which will take into account your arguments as well as my arguments and make a decision as to whether a patent should be granted or not. So let's say you're granted a patent. What can you do if you find someone practicing your invention? You can certainly advise them of your patent rights. You can have an attorney write a letter to tell them, stop doing this, or you'll face a lawsuit. Or you can license your patent to to your infringer in terms of various durations or how much right you want to give up in terms of what they are willing to pay for your rights to use your invention. And my final word is who may apply for a U.S. patent? Anyone, as long as you're a person anywhere in the world. It doesn't matter if you're a little child or an adult, you're all eligible to file for a patent. The only people that are not eligible are people like myself who are employees of the U.S. Patent and Trademark Office. And in conclusion, I'd like to point out something what we call the Inventor Assistance Center. This is a very valuable resource that is staffed by former patent examiners like myself that can give you some assistance in terms of filing application, like which forms to use, where do I mail the application. They can't give you legal advice, but they can certainly guide you through the process and kind of explain things to you as to why things are happening. And in some cases, they can give you some options that are available to you. And that kind of concludes my presentation.
Please join me in thanking Albert for his excellent presentation. At this time, we will be transitioning to breakout sessions. For anyone who wants to attend the Life Science Ventures breakout session, it will be staying here in place in the auditorium, and it will be led by Bethany Barham, one of our supervisory patent examiners in Technology Center 1600. And I welcome Bethany to come up. And Albert will be assisting her in this conversation. We really see these breakout sessions as an opportunity for conversation, dialogue, reflecting on what you've just heard in the presentation, asking any questions that you may have about the patent process, about intellectual property in general. And for those of you who want to attend the Technology Ventures breakout session, we'll ask you to gather at the back of the auditorium, and we will be going to a separate location. For those who are online that want to attend the Technology Ventures breakout session, there will be a new link placed in the chat here momentarily. So if everyone wants to take a quick moment for a stretch break, to step outside, or transition to the other breakout session, we'll be doing that now.
Hello, everyone. I do apologize for the delay. We didn't realize that our person that was monitoring the chat was going to leave, and so we feel really bad because there's not a way for us to see that at this moment because this laptop is broken that's in front of me. I did have some comments about interviewing after you filed an application. However, if there are specific questions here in the room, I would be happy to answer those. As Elizabeth said, my name is Bethany Barham. I'm a supervisor in 1600 examining things like cosmetic, medical devices, small drug molecules, methods of treating. And so, again, we'd be happy to answer questions, or I can go through how once you filed an interview or filed an application, you would ask for an interview in that application. Was there a question from someone in the room that we could get started with, or did you want me to advance in this? Yeah. So we have a really great question here in the room. It says that if you have invented a therapeutic and after you have filed for your non-provisional application, how would you go about as you end up collecting data and doing studies, updating your information in your application? And that's a really great question because as my colleague discussed, you can't add things after you filed it. However, we do have different kinds of applications. So when you file, for example, your first application, and that starts to be examined, if you along the way, like you said, have more studies, maybe on the outcome of that study, you have something you want to add. The way you would do that is you would file something called a child case, and it would be called a continuation in part because you are seeking to change some of the material that's in there. So only the items that were disclosed in that first application would get that priority date to that first application. If you had not disclosed something that you later added to the child case down the road, you would then have to have a different priority date for that. So it would change like your place in line, like we talked about. Um, if, however, say you like filed everything all at once and magically your data matched everything that you filed at that time, um, then you would be afforded the original priority date if you did not have to make any of those modifications. As was discussed earlier, you can amend your claims as long as that original specification that you file disclosed those items. You would just want to be very careful about adding new stuff in because that would get you a specific kind of response from the examiner saying you can't do that. And so you do have to be careful when considering that. It's all about the language. So if the language was in your original disclosure, you could then modify your claim to have that language. If, as the outcome of your study, you had some new language you wanted to add, I'm just going to give an example. Say you figured out your therapeutic not only treats headache, right, but also cures rosacea. But you didn't mention rosacea when you filed. So then you have to file, yeah, a separate one that would have a different priority because you hadn't mentioned rosacea. But say in your first application, you like had thought about all these things and you said, hey, this is going to treat headaches, it's going to treat rosacea, it's going to treat irritable bowel, it's going to treat all these things. If you already had it in there, you could modify your claims as you're going through examination because you already have disclosed that information. But it's all about what you disclosed originally, and making sure that you can have written description for that so that you've described it. Yep, you can make a comment if you want.
Can you use the
You
microphone?
can use the microphone so that people online can hear you.
So what you do in that case is then will determine various dosing. What pathways will give you. There are very sophisticated that can be claimed. Literally, kind of wrapping your patent claim labeling. You will also find that a completely new formulation, for example, release, um, a series of continuous release formulations, and those can also be used to put an evergreen your product. That's actually a very, very complex area, and it interfaces with how you're going to get patent permits. You really want to talk to someone who does pharmaceutical. Don't just go to somebody who. You go to your local patent botanical. They may miss it. They may actually have some good ideas, but that patent term area become critically important. Okay?
All right, were there any other questions from people in the room? So I just wanted to briefly go over the information that after you filed an application, the way you would discourse with an examiner. Um, there are many ways. Obviously, you can pick up the phone and call them. That's one way. The old school way still works. But we also have a way to request an interview that is more technologically advanced than that. So um, basically, we have this portion of our manual of patent examination and procedure. That's what the MPEP stands for. That says tells examiners they should generally grant interviews, and that to do so, it will help clarify issues, lead to mutual understanding between examiner and you, applicant, the inventor, as well as advance prosecution of that application. One way that we have updated the way to request an interview is something called an AIR form. This is an automated electronic way that you can request an interview for the examiner. You would fill out the AIR form, which is on our public facing website, and the mechanism to initiate a conversation. One thing we didn't mention is examiners can live wherever in the United States and Puerto Rico. So perhaps you're here on the East Coast. Perhaps your examiner's in Hawaii. If you're constantly calling them at 8 a.m. East Coast time, you're probably not going to get them. And so this electronic form is a way to avoid that constant calling back and forth. Here's a screenshot of our public page. You would click the AIR request, and there you just go in and enter in the information that you want to consider for this specific application. We've used this quite frequently over the last several years. This data is a little bit dated, but as you can see, the electronic form is steadily increasing. Not only are you electronically entering the information requesting this, the examiner gets an email. Here's a screenshot of part of that email. The examiner gets the date, the time that you're suggesting. Online, it gives you 3 options for dates and times. So again, you're saying, hey, these work best for me. So let's start a dialogue. Which one of these works best for you with that examiner that's examining it? It also clarifies to the examiner to reach out and contact you within 1 business day. So again, just like a phone call, if you left a voicemail there, this puts them on notice. It's in their inbox and says, hey, respond to applicant within 1 day. And then it also goes ahead and it sends you an email. So you have a record of, I filed. It clarifies what your next steps are in setting up this interview. And it also lets you know that while this initiates the conversation, the examiner still does have the ability to grant or deny that interview. There can be various reasons why an examiner would deny it. It could be that the examiner will be out on leave. And in that case, you might want to reach out to their supervisor to arrange something else, another examiner to interview on the case with you. It also could be that, it's just not at the right position in examination. Perhaps the case was just removed from their docket, so they need to wait a couple days in order to arrange this. There could be various little tweaks why they would say we need to wait. But this is like a great way to reach out to the examiner once your case is on their docket. Another thing to keep in mind with all the technology that we now have is that the office conducts business in writing. So the office does not conduct business over text, over email, without your authorization. So if you would like to be able to email your examiner about your application, you need to put that authorization on the record. And there is a specific way that you do that. So we're going to go over that. Without this written authorization from you, we won't respond to your email. Okay. We all know there's like spamming and spoofing, and you can get emails that say they're from PayPal and they're not really. And so we want to make sure we're only discussing your invention with you. And one way that we can do that is we can make sure that you're using language similar to this when you request it. You can even copy and paste this, that's fine. You don't have to use this specific language if you want, but you can at least say, like, I recognize it's not secure, but I still want to communicate this way. There are only a handful of ways that you can request it. You cannot email the examiner that previous paragraph because, again, we don't know if it's you or not. So we have to have it one of these specific ways via EFS Web, the US Postal Service, our customer window, our general central fax, or guess what? The AIR form that we started out with, when you file that form, you can click a button that says, just to discuss this interview, this one time, I want to reach out and have this communication electronically with you to set up this interview process. So if, however, you aren't, you've submitted the AIR form, the examiner calls you over the phone, you can orally tell them, for the purpose of this interview, I want to agree to video conferencing. And it's only for the purpose of that interview. Once you have the interview, that ability to communicate via email terminates. So when you orally tell them that, what that allows them to do, it allows them to send you a Teams link. And that way, when they send you a Teams link, you can have a video conference or a telephone call through that link. Otherwise, the examiner can't send you that email with that link. And so your only option would be a telephonic phone call if you did not agree to this orally. So that's something to keep in mind. Examiners aren't necessarily trying to be difficult, but we do have a certain procedure that business is conducted in writing, and we do have protections in place to protect you all, to make sure that we are really talking to you, that you have requested this via one of the correct ways in writing with us. So another thing to keep in mind is that we will make this of record in your file so that it'll be clear that you have agreed to this. Because again, we conduct business in writing. We want this in your application that you agreed to this. So we will then put that into your file wrapper, which you access via a system that used to be called Public Care and is now the Patent Business Center, or Patent Center. Yes. I've been here so long, I forget what the new terms are. Sorry. Another resource that you have is, say you have filed your AIR request, and your AIR request is, you have your email confirmation. Maybe you haven't gotten that call back or that email back confirming your interview. You are welcome to reach out to PC interview specialist. So PC is tech center. I'm in 1600, which is the medical, and we do plants as well, and biotech. You're welcome to reach out to me if that's where your application is, and we'll try and determine what happened. Occasionally, very rarely, it can be that it got sent to a spam folder. It also could be that the examiner, like I said, is out of office, so they just didn't receive your email and you wouldn't know that. So again, it's not a bad thing to reach out. We're here to serve you, to help you. Feel free to reach out. We will figure out what the issue is and go from there. And we want to make sure that you're able to discuss your application with your examiner and move forward. So this is just, like I said, any questions about how examination proceeds or how you interact with your examiner at this time?
One way of looking at the role of the examiner is we're sort of like the umpire of a baseball game. We call balls and strikes. In this case, it's patentable or non-patentable. And, we our goal is to kind of create a level playing field for all applicants. And we try to be consistent, which is a lot harder than what it looks like, because applications come in a wide variety of forms in terms of quality and in terms of complexity of art. And what's always kind of good practice is to have a good relationship with an examiner. If there's something that if the examiner kind of trusts you in terms of the process, oftentimes it can go a lot more smoother. Things, there's a little bit of judgment call in terms of uh, how sufficient the disclosure is. I mean, no application is absolutely perfect, but oftentimes it's there, it's close enough. And as examiner, most of us examiners are not going to be real sticklers as to things that we know are true that might be not explained as clear as we would like them to be. So oftentimes, if you have an explanation in terms of your response, that can shed a little bit more light to help us understand the invention. And even though those details might be a bit lacking in the specification, as an examiner, I might consider that would be sufficient. The record would be clear, and people would in that field would ordinarily know. What's important really is that for the things that are considered inventive, those are things by definition that you as the applicant know is not known to anyone else. And that's why it's very important when you're writing your application to ask yourself, what is the critical aspect of the invention? What am I trying to protect? And that is the area that you want to provide the maximum amount of detail. Other areas, basic procedures, things that might be known in the art. If it's not as perfect, it can still usually work. Is there a question? Mhm. No, the general. Oh yeah, the question is, what is the level of obviousness? Is it a PhD level or something different? Generally, it's what the law considers a person of ordinary skill in the art. This is not someone who is generally an expert, like a PhD person, but it's not generally someone that's a lay person either. And it can vary depending on the complexity of the art. If you're talking about a biotech field, that person may actually be a PhD type person because of the complexity. But in any case, when you write your application, you should write it at a level that is more understandable. And that's a big difference. Oftentimes, we have someone that is working on a doctorate and they've just presented a paper, and obviously there's something there in that paper that is also patentable. Oftentimes, that paper you're presenting at a conference is at a very high level. And so when you're writing your patent application, you're going to have to add in some more details and more explanation because your reader or your examiner is not going to be at that level of knowledge and sophistication.
I will say in 1600, about 85 had degrees, so most of them are MDs, are PhD, at least math degrees. So most of them do have an advanced understanding. But like my colleague was just pointing out, having the expectations in your specification, if that means something to you, you want to put that in your spec, like how you're defining it, how you're describing it, so that anyone that reads your invention can understand that's what you mean by that. Because as the inventor, obviously, you're critically the expert. You fiercely know what's going on with your invention. And so you want to make sure that you've clearly put a fence around what you mean by that term. So yes, if you have a complicated word and like Google isn't describing it correctly for you and you know it means this because you've spent time in the field, you probably want to write out, this is what I mean by this. And so to be very clear with the verbiage that you're using. So the question was the application, if it were to cross technologies, and it's a medical device, so it involves treating someone with a disorder, but it also has a lot of electrical parts in it. Would it have two different examiners on it? And the answer is no, it would not. There's a single examiner assigned. A lot of our examiners have crossover, so meaning they have experience with both areas. And it would go specifically to an examiner that has that specific type of familiarity and background. And so I know within my own art unit that I am over, I have a couple examiners that do have engineering backgrounds. I have a couple examiners that have biological backgrounds. So where stuff crosses over, they're able to step in and say, oh, I'll take this, this case works for me because I understand it very well. And so it would be the same with you. It gets assigned something called classification. And when it's assigned the classification, that's how we route something to a specific examiner with that specialty that's able to address those areas that kind of bisect or overlap. Uh-huh.
When you're enforcing a patent, oftentimes, it's going to be for a judge that is not an expert in the area. And in some cases, you might actually have a jury, and these people may not even have a college degree. And so trying to explain the technology at that level is going to be challenging in a trial environment. So keep that in mind when you're writing the application, that whoever's looking at your technology may not be an expert in the field.
Yeah, that's a good point. Just because your examiner is, it doesn't mean other people that would be. So any other questions? I do apologize to the people online that we seem to have a dead computer and we're unable to chat. I realize that's not fair to you all, and my sincere apologies. So, but thank you to those in the room that asked some great questions. I really appreciate it. Certainly reach out to us if anything further that could be more than happy to address. I think at 3 o'clock they had the Inventor Hall of Fame upstairs. So if you want to head upstairs, that would be great. You can ask some more questions up there and see our exhibits that we have. So thank you.